Hey guys. Hello, hello, hello. What's up, everyone? It's Debbie. Welcome to my channel. I guess I didn't do it. I guess I didn't set up the redirect. I'm sorry, guys. So we are on day 6, which is closing arguments for the Amber Alert murder trial. Oh, thank you, Michelle. Hey, Jennifer. Hey, Michelle. Hey, Wiggles. Hey, Ken. Hey, Marty. Where's Judy? Uh-oh, we lost Judy. New Hampshire versus Duren was originally scheduled for July 2025. It was ultimately rescheduled for October. Both the prosecution and defense agreed to the reschedule date. An earlier hearing to dismiss the charges against Duren for lack of a speedy trial was denied by the court. Kettles with public defender Hannah K. Keene said the court backlog created the delay. I suck at knitting. I've heard a lot of people tell me that they want to learn to crochet. Maybe I should start my crochet channel back up. Although the problem was trying to figure out how to do the camera. So I need to get a tripod so I can put it on a tripod and face the camera down. I found an app where, because see, the problem is if I've got the camera facing down, I can't see if I'm in frame. Like, because I'm crocheting and the cameras are like that, I can't see. So I found an app where I can like mirror my phone so I can see it on the screen what I'm doing. Um, but I don't remember what happened. I couldn't get it to work right. It was before I had the desktop. So I was doing it on the laptop with the phone and I couldn't get it to work right. So I guess that's what I need to do now that I have the 2 monitors here. It would work out great. I mean, I could even do it. I could even do it like live streams, like live crochet lessons. That would be fun. Like maybe once a week, like a live crochet lesson. That would be fun. We could maybe do that. I don't know. Let me think about that. I knit too, but I'm not good at it. I've probably forgotten how, to be honest, because I got stuck. I was making a big blanket, but they can't. It was like squares. It was a kit that came in the mail, and it was like squares. And then at the end, you like sew all the squares together. You got a big blanket. But the advanced squares that you get towards the end of the blanket, I got stuck. I couldn't do them. They were super hard. So I was like, okay, I'm not a knitter. I'm a crocheter. I make scarves. Like I can knit scarves with like the very basic knit stitch. I can make a scarf. That's about it.
Maintaining all of the previous arguments we made yesterday, I just wanted to point out one additional note based on that
Cool,
video I
Judy.
circulated last
It's
night.
fun.
Starting at the bottom of page 12, continuing on about halfway through page 13, the discussion about the distinction between deadly and non-deadly force
Well, let me
is
turn the fan
asking that
off.
be stricken. I don't think
You
there's
won't be
any
able to hear anything with the fan
dispute
on.
that the force used was deadly, and so I think it is confusing to the jury to have them be doing this weighing of deadly versus non-deadly force, especially in this coming after the second-degree murder, knowing charge where deadly force is not one of the elements caused the death of another is one of the elements.
I thought they did the charging conference
Okay, and
yesterday,
I note that in the defendant's
and we
submission,
skipped it.
which I denied yesterday and is again colloquially
I'm sitting
known
on a
in
heating
these
pad,
parts
so
as the NOMAR
it's
instructions, that
63
in the
here.
defendant's requested instruction, there was a definition of deadly force that was in the defendant's overall requested instructions. I would note that for the record.
Yes, Judge, and reading the current version of the instructions, I think that this series of drafts with what the current instructions are a little bit confusing. And so just seeking to have the clearest and most simple language possible for the jury based on the court's ruling yesterday.
Okay, understood. Anything further, Attorney Gonzalez?
No, no.
Okay.
We disagree, Your Honor. We think these instructions are appropriate. They were contained in previous drafts as they are in this final draft. I don't think there's any reason to take them out. I don't believe it would be confusing for the jury to understand the difference between deadly force and non-deadly force in a situation where they were going to hear arguments after hearing testimony about someone who fired a gun at someone for allegedly hugging someone too tight. I think that's deadly force. That's not deadly force. It's important to know the difference.
Okay, all right.
And so, Judge, that sounds like the state wants this instruction not as it goes to Mr. Duren's use of force, which is the purpose, but to try to somehow bolster the actions of Ms. Naffziger, which is an improper purpose. If there's going to be an instruction on deadly force, it should be about the defendant's use of deadly versus non-deadly force in the state, I think, impermissible purpose.
I would disagree with.
Okay, all right. Anything further, either party?
No, Your Honor.
Okay, all right. Defendant's request is noted. Defendant's request relative to that removal of that instruction is denied based upon the arguments contained by counsel, also based upon arguments as referenced yesterday during the charging conference, the lengthy charging conference, and also based upon the defendant's submission relative to jury instructions, which did include a requested definition relative to deadly force. I think that based upon the overall circumstances, the instructions adequately and reasonably set forth the issues for the jury to be decided with respect to this matter. So over the defendant's objection, that specific portion of the instructions will remain in
Carla.
as drafted, as prepared. Anything further, Attorney Kettles?
No, Your Honor.
Okay, Attorney Spicer, anything further?
No.
Okay. All right. Last bit of business, which I just want to make sure I want to make sure that during just relates to logistics. I want to be able to make sure that I've established that I can think under the circumstances, the best thing is to go back where it was yesterday. And I will simply move down to that portion.
That's gonna take us at least 20 minutes, Your Honor, of taping wires and moving the equipment and resetting up another monitor.
No, when I said yesterday, I meant at the end of the day yesterday. I just meant shifting that to
Back to where it was.
this morning.
This is over here, over this way, this morning.
This morning.
I'm not, no, I'm not talking about,
Thank you, I thought you meant moving it all the way this way, Your Honor,
Yeah.
I apologize.
yeah, I think,
And if the court, Your Honor, if the court needs or requires it after we're done with closing and before, when the court is instructing, we can disconnect the cords and move the TV straight across the room.
yeah, no, I think under the circumstances, I think if I'm here, then I can maintain the most, it's a rather narrow angle, it's a narrow angle of being blocked, but I think I can see everything I need to be able to see for purposes of the record. If I position myself here, any objection from the state relative to anything?
No, Your Honor, we do appreciate it.
Okay, anything from defendant if I,
No, Your Honor, I just know that we now can't see that screen, so I'd just like to test, the state has said this
Yeah,
should still
the
work, but I'd
splitter
like
is
to
still
test
working.
it before the jury comes in, since we now can't see that.
please.
If you just turn it on and make sure it's connected.
So I should ask Madam Clerk, do you object if I? Okay.
Is your monitor power on?
Yes.
It's on this.
It's working on the judge's bench. We're not seeing anything on your judge. Need to wiggle the wires. We'll have to test before the jury can. Blue light. HDMI, there's signal. Went from blue screen to no screen.
Oh, it's on, there we go.
Okay.
Attorney Kennelly, are you
We can now see this, yes.
up and running? Okay. So once again, please let the record reflect that based upon the configuration of the courtroom, the court does find it to be in the interest of the jury and in the interest of those in attendance, as well as counsel. It appears that everybody has the ability to see the monitor. Judge, I will move down to a position directly behind the clerk's bench, from which vantage point, let the record reflect that I will be able to maintain visual contact with the jury as well as the parties in this case. And I've consulted with counsel as to that issue, and there's no objection, so I think we should be sufficient under the circumstances. If an issue does arise, of course, I reserve the right to momentarily pause the proceedings in order to bring some, whatever change is necessary under the circumstances. Anything further from the state before we line up the jury? No.
Thank you. No, Your Honor.
Okay. Anything further from the defense?
No,
At
you're.
this point? Okay, all right. Thank you. Thank you. Thank you.
session, the Honorable Gentleman F. Zell presiding.
Okay, good morning. Thank you. Please be seated. Okay, good morning, members of the jury. Thank you for your punctuality. Thank you for your service. As I told you yesterday, we're about to proceed with closing arguments from the defendant and from the state, and you'll also hear my instructions to you before you retire to the jury deliberation room to decide your verdict. The first matter, obviously, you can see in order to allow the presentation of certain items with respect on the screen, the screen has been moved over here. As a result of that, I'm stepping down here so that I can maintain visual contact with you folks as part of this proceeding. So I will do that during the closing arguments, and I've consulted with the lawyers, and they're in agreement with that. So I will be moving down here just so that I can continue to see what's happening. I can also see the screen from where I am here. So the first order of business, as I mention every morning, because there has been a media presence with respect to this trial, I again ask you if you have had any exposure to any of the media coverage, any information outside the confines of this courtroom, even if it was inadvertent. If you have received any such exposure, I would ask that you please raise your hand to indicate so, and we will address it at that time. Okay, please let the record reflect that none of the jurors raised their hands, so thank you again for following my instructions in that regard. And we are now at the point of closing arguments. And again, closing arguments, jury instructions, and then at that point you will, once I give you the permission, you will be able to talk about the case and the evidence at that time. Okay, so anything further, either counsel, before closing? Okay, I will, if you give me 1 second, Attorney Tails, I'll move down here. I've been offered the clerk's bench. I'll take the clerk's bench. That. Okay, thank you very much.
The law says that Dustin Duren is not guilty. The law says that Dustin was justified when he shot Caitlyn Naffziger. The law says a person has the right to use deadly force when they reasonably believe that someone is committing or about to commit a kidnapping. Caitlyn had kidnapped Dustin's child before. She had a plan to kidnap his children again. She told Dustin he would never see his children again, and she was holding Elowen hostage in front of him. Dustin reasonably believed that Caitlyn was committing or about to commit a kidnapping. Dustin Duren is not guilty. This is a case of secret plans, broken promises, and a father's unyielding love. It is about a Marine reacting to a threat toward his beloved daughter. A horrific tragedy, but not a criminal offense. The law says that Dustin Duren was justified when he shot Caitlyn Naffziger. Dustin Duren is not guilty. Caitlyn Naffziger went to Dustin's apartment in Berlin in late February 2024 under false pretenses. She told him that she was there to drop off his daughter Valen, but she was actually there with a secret plan that she came up with together with her Aunt Brenda, a secret plan to take both kids to Minnesota without Dustin knowing, a secret plan to kidnap the children. And it wasn't the first time that Caitlyn Naffziger had kidnapped one of their children. When the family lived in Las Vegas, Caitlyn walked out of the house with baby Valen in the stroller. She pretended she was going to the park. Hours later, she hadn't returned. Dustin went to the park to look for them, and they weren't there. Caitlyn had taken the baby not to the park, but to the airport. She was flying to Minnesota with their baby, moving out of the state with Dustin's child, without telling him, without getting his agreement, without even letting him say goodbye. Caitlyn had kidnapped Dustin's child before, and when she came to New Hampshire, she planned to do it again. Caitlyn and Brenda had a secret plan to kidnap the kids, to unlawfully interfere with Dustin's custodial rights, to take both Elwyn and Valen to Minnesota without even telling Dustin. But that secret plan was interrupted. Caitlyn had to change her plan once Dustin began to figure out that something wasn't right.
Oh, baby.
And here's what happened. First, Brenda drops Caitlyn off at the restaurant rather than sticking around to take Caitlyn back to her place in Hampton. Then, Caitlyn wants to go back to Dustin's apartment in Berlin, where she had told him before she didn't want to stay. The next day, Caitlyn won't tell him when she is planning to leave. Caitlyn is acting suspiciously. She's ignoring him, doing something on her phone, refusing to engage about what is happening with their children and what she is planning to do. And this is the exact same thing that she did last time she kidnapped one of their children. And so Dustin is getting more and more suspicious. After Caitlyn ignores him all afternoon, Dustin decides that Caitlyn, who's refusing to communicate with him, is no longer welcome in his apartment. He tells her she needs to leave. She ignores him again. He tells Caitlyn it's time to leave and he will drive her back to Brenda's place. And to get ready to go, he puts Valen in the car seat near the kitchen. And when Dustin tells Caitlyn that she's no longer welcome at his place, Caitlyn's secret plan to kidnap the children is interrupted. Caitlyn realizes she is not going to be able to steal the kids away from Dustin without him knowing. And so Caitlyn changes her plan. She reacts. She grabs Elwyn to use her as leverage, to use her as a pawn to try to enact the plan. Dustin comes back into the living room and sees Caitlyn sitting on the couch, holding Elwyn from behind. Elwyn is straddled on Caitlyn's knee. Dustin tells Caitlyn, "Come on, we're leaving," and tries to grab Elwyn to get Elwyn ready to go. But Caitlyn refuses to let Elwyn go. She grabs Elwyn and she pulls her back. And Dustin lets go because he doesn't want to engage in a physical struggle with Caitlyn over their child. So he again asks. He starts to beg Caitlyn to let go of Elwyn. Caitlyn refuses. She says no. And at this point, Dustin's internal radar is going off. Caitlyn is refusing to release their child. She's physically restraining her at risk. The same way that she did
Believe the father.
to become a threat. Dustin is a Marine. He's trained to respond to threats, and he's responding at this point in the way he has been trained. He's at Condition Orange. He feels there is a danger to his child, and at Condition Orange, he's focused in solely on that threat and his need to protect his child. Dustin is begging and pleading with Caitlyn to just let Elwyn go. And Caitlyn again refuses. Caitlyn tells him that unless he pays her $2,000 a month, she is taking the children back to Minnesota and he will never see them again. Let's be clear, she is not asking for child support. She is not asking for money to help her take care of the children. She is asking for money so that he can have the children. She's asking him to pay her money so that he can keep the children. At this point, Dustin hostage, holding her for ransom, saying that she'll only release her if he gives her money. And she's also threatening to call the police and to lie to them, to tell them that Dustin took Elwyn to Berlin without permission, and that she's going to lie to the police unless he gives her money. And while she's threatening to take his children from him and make sure that he never sees them again, she's continuing to confine, to restrain their child. Dustin feels like this is a hostage situation. Elwyn isn't safe. He's panicking. He keeps begging and pleading.
Dude, she's in your house.
Begging Caitlyn
How?
to just let Elwyn go.
What
She refuses.
threat, dude?
She continues her threats that Dustin will never see the children again, that she is taking them from him. And she continues to confine Elwyn in her arms. At this point, the tension is rising. Valen is crying from her car seat in the other room, and Elwyn is crying, both from the argument and from being physically restrained by Caitlyn. The situation is overwhelming. Dustin is scared for Elwyn. He needs to make sure that she's safe. His fatherly instincts, his protective instincts, are telling him that something is seriously wrong. The woman who kidnapped his child before is telling him she's going to do it again. And this time, he can see her physically holding their child hostage. Dustin, trying again to protect his daughter, tries to take Elwyn for the second time. And Caitlyn pulls her, yanks back again, and Dustin lets go. Caitlyn continues her threats to take the children and ensure that Dustin never sees them again. Caitlyn is escalating. She's getting more and more aggressive. She's kidnapped one of their children before. She's threatened to take them from him before, but this time is different. This time, she's holding his daughter hostage, holding her for ransom right in front of him. This time, she's confining his daughter, restraining his daughter, using physical force against his daughter. And Caitlyn had been on the phone. Dustin's thinking, is there someone outside, maybe Brenda, waiting? He's thinking, she's saying she's taking my kids from me. She must have a plan. And Dustin tries one more time to take Elwyn, to free her, to make sure she's safe. This time, he tries harder. He tries to grab one of Caitlyn's wrists with one hand and wrap his arm behind Elwyn with another so that he can free Elwyn from Caitlyn's restraint. But instead of letting go, Caitlyn gets more aggressive, more physical. Caitlyn braces her leg against the table. She yanks back even harder than she has before. She pulls, she twists, she bear hugs Elwyn. And Elwyn lets out a scream, a cry of pain from being yanked back by Caitlyn. Dustin and Elwyn lock eyes. And Dustin sees Elwyn's fear and her pain. And hearing Elwyn scream is horrific. It's a line that has been crossed. Elwyn is about to be kidnapped. Elwyn in immediate danger. And so Dustin acts
By her
immediately.
mom?
And he very, very quickly, with deliberate motion and without conscious thought, acts the way that he has been trained.
He just didn't live in New Hampshire, dude.
The only thing in his mind is save Elwyn. Right is so immediate, a danger so imminent that you need to take action. Like he had been trained, instinctually, automatically, he grabs his gun, chambers around, grabs the collar of Elwyn's shirt with one hand, and pulls her as far toward him as he can while Caitlyn is still restraining him. And while Elwyn is still in Caitlyn's arms, still being held hostage, he fires a single shot. And immediately after he shoots, Elwyn is released from Caitlyn's arms, and she is freed. Elwyn wraps her arms around Dustin, and he runs out of the house and puts her in the car. He talks to Elwyn and makes sure that she is physically unharmed. But he's still in this heightened mode, this need to protect his kids. He grabs what he thinks they would need, he puts Valen in the car, and he drives. And once he's on his way, once he knows both kids are safe, once he's out of condition red, he feels horrible. What has happened is tragic. Caitlyn is someone he cares about and who is important to him and his children. He knew that he had been acting to save Elwyn, but that doesn't mean he isn't devastated by what just happened. And he knows he needs to turn himself in, but he wants to spend some time with the girls first to make sure that they are unharmed, to make sure that they are okay, not just physically, but mentally. He calls his mom. He tells her he shot Caitlyn. He tells her to call the police. And then he turns his phone off so he can have some time with the girls. And he drives, checking in on the girls along the way. The following morning, he turns around and heads back to New Hampshire to turn himself in. And he is hoping to have a meal with the girls before he does so. But the police locate him first. He cooperates, he complies with their commands, he makes sure they know that there are children in the car and exactly where his gun is located. And he does these things to make sure his children are safe. And then he speaks with the police, voluntarily, although he's under no obligation to do so. He's still in shock when he tells them what has happened. He feels horrible about what has happened, and he doesn't want to blame Caitlyn. He doesn't know New Hampshire's law on justification, and he doesn't know the law of defense of others. All he knows is that he was acting to protect Elwyn. When the state played the video of his interview, the last thing we heard Dustin say was about Elwyn. He says, not that it even justifies anything, but it's like, she's just my everything. And Dustin's right that Elwyn is his everything, but he doesn't know the law. The law says that Dustin is justified. The law says that Dustin is not guilty. The judge will instruct you on the law. He will tell you, evidence has been presented that Dustin acted in defense of another with respect to each of the charges. He will tell you that you must find Dustin not guilty unless the state proves beyond a reasonable doubt that he did not act in defense of another. And the state cannot meet its burden. Dustin did act in defense of Elwyn. He is not guilty.
She wasn't in danger, doofus.
The judge will tell you that when looking at the evidence that Dustin acted in defense of Elwyn, you should consider all the circumstances surrounding the incident.
Ew, what's
You
that
should consider
squeak?
how he acted under the circumstances as they were presented to him at the time, and not necessarily as they appear upon detached reflection. The judge will tell you that Dustin had the right to use deadly force to defend Elwyn if he reasonably believed that Caitlyn was committing or about to commit a kidnapping. Dustin's belief that Caitlyn was about to commit a kidnapping was reasonable. Dustin had the right to use deadly force. Dustin is not guilty. And consider all the evidence you've heard that Caitlyn was about to commit a kidnapping. And I'm going to highlight just 4 of the many things that you've heard. First, Caitlyn's own aunt told you that Caitlyn had a plan to take the children to another state without telling Dustin. Second, Caitlyn had kidnapped one of their children before. Caitlyn had taken one of their children, pretended she was going to the park, and actually gone to the airport to take Valen out of state, to move her to Minnesota without even letting Dustin know. Third, Caitlyn was holding Elwyn hostage, telling Dustin he was never going to see either of their children again. And fourth, Caitlyn was willing to harm Elwyn rather than let her go. Caitlyn was in fact attempting to commit a kidnapping. We heard it from her own family member. And therefore, Dustin's belief that she was about to commit a kidnapping is not only reasonable, it's correct. During jury selection, we talked about the fact that parents have a responsibility, a duty to protect their children. And that's what Dustin was doing. He was protecting his child, ensuring she was not kidnapped. The facts are clear. Caitlyn was about to commit a kidnapping. You heard it from Brenda, and you heard it from Dustin. The law is clear. Because Dustin reasonably believed that Caitlyn was about to commit a kidnapping, Dustin had the right to use deadly force. Dustin is not guilty. The state gets to make its closing argument last, and Dustin won't have the opportunity to respond. So let's talk a little bit about what the state is likely going to say and about the evidence the state presented or didn't present during the trial. First, you should not automatically believe
And
that
she
what the
wasn't in
state is
danger.
telling you is correct. The state showed you that in its opening statement. The state's claims about what the evidence would be in its opening statement were wrong.
Sitting on your mom's lap is not being in danger.
Here's one example of when they were wrong about the evidence. The state told you, even put up on its big fancy screen, that Dustin was asked, "Fair to say you know you are endangering Elwyn," and that he said yes. But the sergeant, the police officer, the state's own witness, told you that what actually happened was the exact opposite. Dustin said, "Could it be that I'm endangering Elwyn by what I did?" And I would very much say no. Dustin was asked, "Fair to say you know you weren't endangering Elwyn," and that's what he said yes to. What the state told you about the evidence was wrong. What the state told you about the evidence was misleading. It told you that Dustin said the shooting was very deliberate, but it didn't tell you that that wasn't all he said. He said it was very, very fast, very deliberate. And that was misleading. That left out half the sentence to create a misimpression. The state also got it wrong when they said that Dustin grabbed Elwyn, she was in his arms, he stepped back, and then he shot. That's what the state said happened in its opening statement, and that's not what happened. And the state knows that's not what happened. The state had proof in their evidence that what they are saying happened is not true. Their claim that he had Elwyn in his arms and stepped back is not true. How do we know that? We know that because the range of fire was close enough that Caitlyn's hair got caught in the slide of the gun.
Objection. May counsel approach.
Can't you just say facts not in evidence?
I'm striking the closing argument, disregard it, and I will return to my seat now. Okay.
Exhibit 24A. They didn't talk to you too much about State's Exhibit 24A. They talked to you about the gun, but not about the other half of the picture. The other half of the picture says hair removed from slide. So if you will take it back with you, and you can see it right now. The police tampered with the evidence. They took the hair
Objection.
from the slide.
May council approach.
Yes.
She just said police tampered with the evidence? Good Lord. Where'd the judge go?
The state didn't present any evidence that it tested the hair. The state didn't present any evidence about whose hair it was. The state didn't have its witnesses talk to you about the hair that was removed from the slide of the gun. And the state didn't talk about the fact that hair had been removed from the slide of the gun during its opening argument.
Wait, now she can talk about it?
And we can't know whose hair that was because the state didn't present any evidence, because the state didn't test it. But we can think about where Dustin said his arm was when he fired, and where Caitlyn was in relation to that gun and the slide of that gun. We can think about the fact that Caitlyn's hair wouldn't have gotten caught in the slide of the gun if he had grabbed Elowen, taken a step back, and then shot.
Well, why didn't you bring it up?
Caitlyn was still holding, still restraining, still confining Elowen when Dustin shot her. Dustin was justified. Dustin explained to you that Caitlyn was still bear hugging, still restraining Elowen when he fired the gun. He explained to you that he pulled onto the collar of Elowen's shirt with one hand to pull her forward to try to get her, but that she wasn't released from Caitlyn's arms. She wasn't safe until after he shot. The state may try to argue that that's not what he told the police, but you have the video. Watch it. They say that he stepped back. Nowhere in that interview does it say that he stepped back. Nowhere in that interview does he say that Caitlyn had let go before Elowen was shot. I apologize, that Caitlyn had let go of Elowen before he shot. I expect the state will make a big deal of the fact that the medical examiner told you that there was no evidence of close-range firing. But that just means that some of the markers that the medical examiner would look for weren't there. The medical examiner told you that he couldn't say exactly where the shot was fired. He said that it's possible, he said on cross-examination, that it's possible to fire from close range without those markers being there, especially when there is hair overlying the entry wound, like there was in this case. There wouldn't be gunshot residue on the skin if there was hair in the way, and there's been no evidence presented that the state tested Caitlyn's hair for gunshot residue. You have better evidence than the medical examiner, who can't say anything with 100% certainty, who wasn't there, who doesn't know whether or not this was justified. You have the photos from the apartment and from the autopsy. I'm not going to put them up again, but Caitlyn was sitting on the couch facing forward. She was shot in the side of the head. Dustin couldn't have had Elwyn in his arms, taken a step back, and then shot. If he had done that, she would have been shot in the forehead from the front. Instead, what happened, what the evidence shows, is that Dustin was grabbing Elwyn's collar with one arm and shooting with the other, while Caitlyn was still confining and restraining Elwyn. It's the only thing that makes sense with all of the physical evidence, that which was presented to you and that which was not, and which was not tested. It's the only thing that makes sense with the location of the gunshot entry wound and exit wound. It's the only thing that makes sense with the trajectory of the bullet down through the drawers. The state's got it wrong when it describes where Dustin was and where Elwyn was when the shot was fired. The evidence that the state presented about what Elwyn says happened also gets it wrong. It's also misleading. The only evidence the state presented about what Elwyn says happened comes from a doctor, not from a police officer or an investigator. Let's go over exactly what Dr. Robertson said. Dr. Robertson was leading Elwyn. She was asking her pointed questions, trying to figure out whether she had any medical issues, based on the only information the doctor had at the time, which was that Dustin shot Caitlyn. Dr. Robertson did the best exam she could with that limited information. Said that she asked Elwyn if there was anything wrong with her, and at first, Elwyn said no. And only after Dr. Robertson guided her, led her to the answer, did Elwyn eventually say that her ear hurt and pointed to her left ear. Dr. Robertson had to ask her a very specific question to get that answer. She had to ask her how her ear got hurt.
That's because that's what you have to
Elwyn
do when
answered
kids
anyway.
that age.
She said, Mom and Dad were fighting, and Dad hurt Mom and me, and there was a lot of blood. And Elwyn's ear hurt because she had heard a gun that Dustin shot. That's not up for dispute. But think about what Dr. Robertson didn't know to ask. Dr. Robertson asked Elwyn if she was hurt anywhere else on her body, and Elwyn said yes. But Dr. Robertson didn't know what else had happened. She didn't know that Caitlyn had grabbed Elwyn, yanked her, pulled her, twisted her, made her scream in pain. And so the doctor couldn't get the right information out of Elwyn. The doctor didn't know what questions to ask to help Elwyn explain why else her body hurt. Elwyn was just 4 years old, and the doctor, who didn't know everything that had happened, couldn't ask her the right questions to get the full story from her. The state didn't have Elwyn testify. They didn't present testimony of any police officers or investigators who had spoken to Elwyn. They didn't give you the full picture of what Elwyn said.
Lady, she's
They
4,
gave you one small glimpse
5.
from a doctor who was there to treat Elwyn, not to interview or investigate. And the doctor didn't know what had happened and didn't know what to ask. You didn't hear the full story of what Elwyn said. The state also presented evidence in a misleading way when it cross-examined Dustin. It tried to suggest that Dustin never told the police that Caitlyn threatened to take the kids. But Dustin told the police over and over again that Caitlyn threatened to take the kids. You have Dustin's statements to police in evidence, but some of the times when he tells the police that she threatened to take the kids away from him, both before the incident and during. 28 minutes and 13 seconds, he says, she just kept threatening, well, okay, I'm going to take the kids away. 28:47,
Hey,
he
Nancy.
said, every month it was basically the same thing of her wanting more money with threats of taking the kids away. 31:11, he said, she was basically threatening to put me in prison and take the kids away. 32:39, she threatened to arrest me and take the kids away. He starts discussing the day of the incident. 59:18, she started getting more and more aggressive about how, no, I'm going to take the kids from you. An hour and 16 seconds. The one thing that does set me off is these continued threats of taking the kids away from me. An hour, 1 minute, 58 seconds. Her just again threatening to take the kids and saying she just wasn't going to leave and that she wasn't going to leave and that she was going to take Elwyn and Valen back to Minnesota. By an hour and 32 minutes into this interview, he said it so many times that the police start talking about how she's threatening to take the kids away. Dustin told the police, and he told you, that she threatened to take the kids away over and over and over again because that's what happened. I've given a lot of timestamps, but I'd ask you to take a listen to the video around 1 hour and 40 minutes. That's when Sergeant McLaughlin asks, and I'm quoting, the training you're talking about is marksmanship training, not specifically hostage? Because that's my first thought, was you're trying to remove Elwyn from a harmful situation. Do you have training in hostage-type scenarios? That's the investigating officer's first thought. That Dustin was
That
trying to
doesn't
remove
mean he
Elwyn
thought he
from
did the right
situation
thing.
and wondering if he had training in hostage-type scenarios. That was the police officer's first thought, because Dustin was trying to remove Elwyn from a harmful situation, from a hostage-type scenario.
That's what you got from that lady?
Think about the evidence that the state didn't present to you. The state didn't call Brenda. The state didn't talk to you about or present evidence of testing of the hair stuck in the slide. The state didn't ask the medical examiner about how hair impacts gunshot residue. The state didn't have a police officer who spoke to Elwyn testify. The state had Dustin's phone. They had his text messages with Caitlyn, his text messages with Lori, his text messages with Rob, but they didn't show them to you. They didn't want you to hear what they said. Those text messages
Hey, Carla.
prove that what Dustin told you is true.
Objection.
And this is why We start late, folks. Especially with this trial.
Members of the jury, based upon the state of the evidence, I am going to strike the last sentence of the defendant's closing argument and instruct you to disregard it. Thank you.
I expect the state is going to try to argue that Dustin didn't reasonably believe that Caitlyn was committing or about to commit a kidnapping because she was the children's mother and because there was no court order on custody. But that just doesn't make sense. Think about it.
There you go, no court order.
Imagine if Caitlyn's secret plan had gone into effect. Dustin would have woken up in the morning to both of his children gone, stolen, kidnapped, taken away to another state. We are talking about unlawfully taking children away from their father to another state permanently without him knowing. We are talking about coming up with a secret plan.
He would have
We are
figured
talking
it
about
out.
Deception. We are talking about Caitlyn planning to commit a crime. Dustin reasonably believed that Caitlyn was about to commit a kidnapping. And the fact that she's the children's mother doesn't change that. The state's also got it wrong. They're missing the point when they spend hours and days focusing on cell site location data and testimony from someone who saw Dustin's car and presenting a whole lot of evidence of things that aren't in dispute that Dustin told you happened. They're focusing on what happened after the shot was fired. But what matters in this case is what was happening immediately before and while the shot was fired. This whole case is about Dustin's defense of Elowen. That Dustin was justified under the law.
Oh, tell him I said hi, Nancy.
Dustin wanted to spend more time with his girls. That's not a crime. He's not charged with anything related to that. It's only human nature. It's a father wanting to make sure his kids are okay. He wasn't denying what had happened. He called his mom and told her. He knew his dad would call the police. He made sure they knew the girls were okay, and he told them that after he took some time with the girls, he was going to turn himself in. He didn't deny what had happened when he waived his right to remain silent and spoke voluntarily with the police. And he didn't deny what had happened when he took the stand here yesterday and spoke to you. Nothing that happened after the fact changes what happened in that apartment. It doesn't change that Dustin reasonably believed that Caitlyn was about to commit a kidnapping, that Caitlyn had a kidnapping plan, that Dustin was justified under the law.
Yeah, I don't think he was.
The state is wrong about whether Dustin's use of deadly
Well,
force
that's
was
good.
justified.
I was worried about him.
Perspective. Think about what was going through Dustin's mind at the time. Dustin didn't think there was any help available. Dustin had spent months trying to figure out how to deal with Caitlyn. He called his parents. He called her parents. He called a lawyer in Minnesota and one in Vegas. He called the Berlin Police Department, and they told him they couldn't help. Think about that time a year or two ago when he called the police in Vegas and they didn't show up until after the threat was gone. Think about the fact that Caitlyn had kidnapped his child before, and she had a plan to do it again. The judge
It's
will
their
instruct you
child, not
that you
just
should consider how Dustin acted under the circumstances as they were presented to him at the time, and not necessarily as they appeared upon detached reflection. Consider how he felt at the time, in that moment that Elwyn is screaming in pain. Consider his perspective as a Marine, his perspective as a father whose child had been kidnapped before by the very same person who was holding his child hostage in front of him. And I'd imagine the state is going to talk a whole lot about other things that they think Dustin should have done instead. But think about what's going on here. Dustin tries to de-escalate the situation. He tries to talk to Caitlyn.
Did he?
She won't talk to him.
Did he really?
He begs her and pleads with her to just let Elwyn go, and she refuses. He tries to just grab Elwyn, and Caitlyn won't let him. He begs again for Caitlyn to let Elwyn go, and she refuses. He tries to get Elwyn a second time, a third, and the third time he tries even harder, grabbing Caitlyn's wrist with one hand and trying to pull on Elwyn from behind. And it is only once Caitlyn physically harms Elwyn, only when Caitlyn is willing to go to the length of letting her child be harmed, be hurt, to enact her kidnapping plan, that Dustin acts. Even when Dustin grabbed the firearm, even when Caitlyn heard him chamber around, she still didn't let Elwyn go. Even when Dustin pointed the firearm at her, Caitlyn still didn't let go of Elwyn. Caitlyn was still holding Elwyn hostage even after he had taken those steps. Those steps of grabbing the firearm and chambering it weren't enough. So Dustin did what he had to do. Dustin reasonably believed the amount of force he used was necessary because nothing else worked. And again, you will be instructed to think about Dustin's actions under the circumstances as they were presented to him at the time, when he acted in the heat of passion. Consider the stress, the anxiety, the fear, and the need to take immediate action to prevent Elwyn from being hurt, to make sure Elwyn was safe. Your role is not to Monday morning quarterback. It's to think about what Dustin was seeing and thinking and feeling in the midst of this horrific situation when he had to make a split-second decision and act instinctually. And from that perspective, Dustin did what he had to do to save his child. Dustin was justified. Think about the fear that Dustin felt, hearing Caitlyn tell him he was never going to see his children again, seeing Elwyn restrained, confined, held hostage in front of him. And think about the fact that he did not take that action until Elwyn had been harmed, until Elwyn screamed in pain and locked eyes with him, until the line had been crossed. He was a Marine and a father responding to a threat. He was a Marine and a father protecting his beloved daughter. This is a tragedy, but it's not a crime. When you hear from the state, I ask you to keep in mind everything we've just talked about. I ask you to keep in mind that Caitlyn's own aunt told you that Caitlyn had a plan to kidnap the kids. Keep in mind that if Caitlyn had a plan to kidnap the kids, it was reasonable for Dustin to believe that she had a plan, that she was about to kidnap the kids. Keep in mind that the law says that Dustin had the right to use deadly force if he reasonably believed that Caitlyn was committing or about to commit a kidnapping. The judge will instruct you that you must apply the law and that you must hold the state to its burden. When you do, you will return the only fair and just verdict, the only one supported by both the evidence and the law, one declaring Dustin Duren not guilty.
Mr. Duren will take a 10-minute break. Turn your 10 minutes.
That's fine, Your Honor. I'm ready now or whenever you'd like.
Okay, we'll take a break now, mid-morning break now. We'll reconvene at 10:25. Again, please do not discuss any aspect of the case or the evidence amongst yourselves. If anyone, you see anyone do that, we'll be in recess until 10:25. Thank you. All right.
He said his training took over and he just snapped. No, that's not PTSD. He was not in a combat situation. His daughter was not in any danger. She screamed because he jerked her away from her mom, and her mom still had a hold of her. They were playing tug of war with this kid. That's why she screamed. Kids are not toys you play tug of war with.
Okay, thank you. Please be seated. Again, let the record reflect, I'll be moving to adjust my position where I can maintain visual contact. Attorney Duren, you ready to proceed?
Thanks, Your Honor. Just checking, Your Honor, you're all set?
Yes.
Ladies and gentlemen, this was not an accident. This was not defense of others. This wasn't done to prevent a kidnapping. It was murder. He knows. He's changed his story over time. He's crafted what he told the police after he was caught. He's tried to blame Caitlyn Naffziger for her death. The real victim here, the victim that you're here to decide this case about, is the unarmed woman who the defendant shot in the head, who was sitting on the couch with a child. Now, yesterday, when he testified towards the middle of his cross-examination, he told you in his own words, live from the witness stand, why he shot and killed Caitlyn. And he told you that in that moment, right before he got his gun, right before he pulled the trigger, that she hurt his daughter. His daughter. If you listen to defense counsel's opening, I lost track of the number of times that they described this child as his daughter.
Didn't I say that? Didn't I say
Caitlyn
that?
Naffziger, according to the defendant, hurt his child. She hurt her by holding her tight, hurt her by pulling her close, hurt her by pulling the child away when the defendant tried to grab her.
Didn't I say that? I said that. I want it on the record that I said that. I called it.
Let's be clear. Caitlyn was holding their child, her child, as much as his. A child she carried for 9 months, a she gave birth to a child, their hug with as he could. They had equal rights.
That she hadn't seen in how long?
Rights they had been arguing about since August of 2023. On the day that the defendant killed Caitlyn, he was angry. He was yelling. He didn't want to admit that during his testimony, right? I maybe yelled 1 to 2 sentences. The defendant needs to be in control. That is clear from his testimony. It is clear from his statement to the police. He's a person who operates best under stress. He needs to be the leader. He wants to have a plan, and you know what? Once a plan is made, there are no changes. Plans never change. But on that day, on February 29, 2024, the defendant was not in control of Caitlyn. The defendant into custody. He was asking Caitlyn to drop her child, the youngest one off, their child, with him, to then see her daughter, their daughter, who she hadn't seen in a month and a half, sleep over and leave. Think about that day and what the defendant's behavior must have been. How his frustration over the situation, over the change in plan, turned to anger over the course of a day. It must have. It doesn't make sense that it wouldn't have. He didn't want Caitlyn there in his apartment. He wasn't happy that she had spent the night. It wasn't part of his plan. He wanted her to leave. He testified and told the police that during that day on February the 29th, every 15 minutes or so, I think he said 15 to 30 on the stand, but he said 15 during his statement to police. Every 15 minutes for several hours, up to 5, he agreed with me yesterday, probably between noon and he went to the room where Caitlyn was with her daughters and asked when she was leaving. He hovered in the doorway. Her being there wasn't part of his plan. He wanted the girls with him and he wanted Caitlyn gone. He told the police that. He told the police that he'd even discussed it with his mother. For at least 5 hours, every 15 to 30 minutes, he went to that doorway and he said, "When are you leaving?" He asked how she was leaving. When is her ride coming? And she was ignoring him. She wasn't ready to leave her children, their children, behind. The defendant was frustrated, but he became angry. He was angry because she wasn't doing what he wanted, wasn't following his plan. He was angry because she was ignoring his questions, because she didn't want to leave. He was angry because they were having the same dispute they'd been having since August of 2023. And Caitlyn, we know, apparently, didn't want to hand their 4-year-old daughter over to the defendant while he was yelling and angry, while he was pulling at the child and trying to yank her from Caitlyn's arms. Caitlyn knew how angry he was, and she knew that he was dangerous. She didn't know how much of a danger in that moment, but he'd show her. You know that Elowen told doctors at the hospital what happened. You know that she asked them to look at her ears because they hurt from the loud noise of the gunshot. That Dr. Robertson, somehow not knowing what happened, led Elowen to make the statement that she made. It simply doesn't make sense. You heard testimony from Dr. Robertson where she explained to you how she approaches a child. Hi, I'm Dr. Natalie. Can you tell me what hurts? That's not leading. That's not trying to get an answer from a child. It's trying to find out where they hurt and where to examine. And when Elowen was asked what hurt and where to examine, she said that mommy and daddy were fighting. She said that daddy hurt her and mommy, that mommy had lots of blood. Elowen didn't have any bumps or bruises from being held tight by her mother. She didn't say that mommy hurt her. She said daddy did. The defendant hurt them both, and he hurt them in the worst way possible. On February the 29th of 2024, Dustin Duren murdered Caitlyn Naffziger. He killed her as she sat on a couch in his living room. Remember the testimony. And ladies and gentlemen, you are the deciders of the facts, right? If defense counsel stands in front of you and they tell you something and you disagree with it, that's what you should do as jurors. You're the judges of the fact. If I stand in front of you and I say something that you don't agree was the evidence that you heard, that's what you should do. You should discard what I tell you and pay attention to the facts that you heard in testimony. But the facts that you heard was testimony from Dr. Weinberg, right? And he talked to you about even under cross-examination, his testimony was that the defendant had to be 3 feet away or more away from her head when it was fired. And so we know that the defendant stood at a distance when he shot her in the side of her head. When Dustin Duren fired a single bullet from this Beretta 9mm handgun, Caitlyn Naffziger was wrapped up on the sofa in their daughter's pink unicorn blanket. Her foot was on the coffee table. She had no shoes on, and there were none close by. No knife, no weapon of any kind, nothing. She wasn't even looking at the defendant. You know, defense counsel stood in front of you and said, well, if it happened the way the state described, well, then Caitlyn would have been shot in the head. Well, not if she wasn't a threat, not if she wasn't watching him, not if they weren't engaged in any kind of dispute or argument like the defendant has said. We know from the evidence that she was shot here in her temple. That's what the doctor can tell you. In terms of positioning, that's based on how they were interacting at the time, and Caitlyn wasn't looking at Dustin Duren. The defendant's bullet entered the left side of her head at her temple. It traveled straight through her brain. When the bullet exited on the right side of her head, it took pieces of her skull with it. The bullet continued in a straight line, cutting into the built-in bookcase behind her, ricocheting through the drawers. You know, Caitlyn was likely dead before Elowen even saw the blood, before Elowen began screaming about the noise of the gunshot hurting her ears. The defendant didn't check to see if Caitlyn was alive, to see if she could be saved. Instead, he ran. He loaded his car with changes of clothes. More than you needed for one night, more than you need for 2. He put his desktop computer tower in the trunk. He turned out the lights, he turned the key in the deadbolt and locked the door. He drove south. He went dark. He made it a point that you didn't need to know about his phone searches or his phone records. You know what they told you, those records? They told you when he left his house. which gives you an idea of when he killed Caitlyn. Those records that you have in evidence show you that around 6 o'clock, between 5:30 p.m. and 6 p.m., on the 29th of February, the defendant began to leave his home. Caitlyn was dead, and he was on the run. A person who's justified, who acted lawfully, who acted to defend someone, they do not run. They stay in place. They do the right thing. They ended the threat. They call the police and they tell them what has just happened. It's the first thing that they say. They yell it at the top of their lungs. They scream that they had no other choice. But the defendant didn't do that, and he didn't do that because he had choices. There were options that didn't involve putting a bullet through an unarmed woman's head. He knew then that what he had done was not justified. It wasn't in defense of someone else, and it wasn't to stop a kidnapping. It was a murder, and he acted like a murderer. You know, a murderer packs their clothes and drives through the night with 2 little girls after he has killed their mom and left that mom dead in his living room. A murderer turns off his phone so the police can't find him. A murderer needs 16 hours to tell the police that something happened. And that's how long Dustin Duren had. From 6 p.m. or 5:30 p.m. when he left that house until he was taken into custody at 10:30 the next morning, he had 16 hours. But you know what's even more is a murderer needs 3 hours of background testimony at a trial before he can tell his new version of what happened. A murderer needs 1.5 years to explain that his actions were an act of defense of others. You know, ladies and gentlemen of the jury, the defendant thinks in this case that he can fool you, that he can put this claim of defense of others in front of you, and that you will jump on it and detract from his actual actions and his intent. When you were chosen as jurors in this case, each of you individually, you brought your life experience with you. You brought your ability to make assessments and to make judgments, and you brought your common sense. You know, we keep a lot of things that you're not allowed to bring with you into the courthouse or bring with you into the jury deliberation room, but your common sense isn't one of those things. Your common sense and your knowledge about people, it stays with you when you come in the courthouse. It stays with you here in this courtroom, and it will sit with you as you go into that back room to deliberate. Your common sense and your experiences is why you were selected. And it gives you a framework and a basis to evaluate what happened on February the 29th of 2024. This is a framework that you can use to evaluate the witnesses, the testimony, and the evidence. Your common sense plus that evidence and plus the court's instructions are the tools that you have. They're the only ones we give you. But they're the tools that you have to fairly and impartially weigh the evidence in order to determine whether the state has proven beyond a reasonable doubt in this case that the defendant killed Caitlyn Naffziger, and that when he did that, he was not acting in lawful defense of others to prevent a kidnapping when he shot her in the head. You, as I've explained, are also the judges of fact. And that is why you use your common sense to evaluate that testimony. You give the testimony of each witness what you believe it deserves, not what the state tells you and not what the defense tells you. In terms of the first part of your job, determining whether the state has proven beyond doubt that the defendant killed Caitlyn Naffziger, At the beginning of this case, we stood in front of you, my colleague, and told you that this is not and would not be a complicated finding for you. This isn't a whodunit, that by the conclusion of the evidence here, you would know beyond a reasonable doubt that the defendant is the person who shot and killed Caitlyn Naffziger. Throughout the past week, you have learned that he confessed to his parents, he confessed to the police, his gun is the murder weapon, that he knows that when you point a gun at a person, you intend on killing, that he knows exactly where the bullet went, and that he has testified now in this case that he is the one who fired the shot. You know beyond a reasonable doubt that he killed Caitlyn Naffziger. The defendant is facing several charges related to this case. Those charges include second-degree murder, reckless conduct with a deadly weapon, and endangering the welfare of a child. The judge has explained some of the law to you, and shortly he's going to explain to you what it means to commit second-degree murder. The defendant, to be clear, is charged with two variations of second-degree murder.
You don't
He's
work.
charged with knowing second-degree murder and reckless
You go to
second-degree
work and
murder.
watch me all
The
day.
difference is in what he was thinking at the time that it happened. The court will talk to you about those charges of reckless conduct and endangering the welfare of a child, and those charges, so that you understand, are related specifically to the defendant's actions in which he placed 4-year-old Elowen in danger or violated the duty of care that he had to her. The facts of this case as presented to you over the past week and a half, have demonstrated that each of the requirements that you need to find the defendant guilty of these crimes beyond a reasonable doubt have been met. Let's demonstrate what I'm asking, or what the state, what everyone's asking you to do here. I want to look at the factors of second-degree murder. Up on the screen you have in front of you part of what the judge will instruct you on. The judge is the judge of the law, just like you are the judges of the fact. So his instructions will hold, okay? Now you have to decide whether the defendant caused Caitlyn Naffziger's death. Again, this has been proven. The defendant admits that he was the person who pulled the trigger, that he shot Caitlyn in the head. He caused her death. For knowing second-degree murder, you also have to consider whether the defendant acted with a knowing intent to cause her death. That means that when he fired the gun, he was aware that such conduct would cause Caitlyn's death. You should consider all of the evidence that you've heard throughout this case when you decide whether the defendant knew that he would cause Caitlyn's death by shooting her that day. You've heard about the defendant's ability with a gun, his military training. He testified that he raised the gun, and he admitted that the purpose of pointing a gun at someone is to kill. There is no other purpose. He knew that this would be the result when he pointed his gun at Caitlyn and when he pulled the trigger. He knew exactly where the shot would go and the damage that it would cause. For each of the charges that we're talking about, you must also consider the defendant's claim that he was acting in defense of others. Specifically, the judge will instruct you that in this case, acting in defense of others means that the defendant had to not just reasonably believe. Now, defense talked to you, it was a reasonable belief. But you'll note that on the screen, and as the judge will advise you later, that there's actually another portion of it. This belief has to be an actual belief and a reasonable belief. We expect and anticipate that, the defendant testified from the witness stand that all he had about this kidnapping plan or kidnapping idea were his suspicions. Suspicions are not an actual belief, they're just suspicions. The defendant didn't have an actual belief here, and he didn't have a reasonable belief here. And if he didn't have those two things, if his belief wasn't actual, if his belief wasn't reasonable, then he was not lawfully acting in self-defense, and his murder of Caitlyn is not justified.
Nancy,
There's
that's
a lot of discussion about where Elowen,
want you
where
to be
the
able to get
4-year-old
food.
is at the time that the defendant fired. And that's one of the things that you can consider both in the charges of reckless conduct and with respect to the defendant's claims. At the time that the defendant had fired, if we look specifically at his claim that Caitlyn was kidnapping, right? At the time that the defendant had fired, he had grabbed Elowin with his left hand and he shot Caitlyn with his right. With that action, the defendant ended any argument he might have made that he had shot Caitlyn to prevent a kidnapping. It was over, it was done, and he had the child. But it's the state's position that there was never any kidnapping. Caitlyn was never about to commit a kidnapping. She was not about to do anything. She had made her position clear to him. She was refusing to leave, and she was seated on the couch holding their daughter. In the defense's opening statement, they told you that the defendant pulled Elowin to safety before he fired. He told the police in his statement that he had grabbed her, pulled her back, and then shot. But yesterday in his testimony, he stated that he had just pulled her forward by her shirt and held her in place. He implies that she was still on Caitlyn's lap when he fires the gun. But the defendant's testimony doesn't fit with the evidence. Dr. Weinberg testified that he found no evidence that the shot occurred within close range. He testified, even on cross-examination, that his opinion was that it had to be 3 feet or more away. He found no evidence of stippling. Now, this isn't gunshot residue, it's stippling. Little burns of gunshot powder embedded into Caitlyn's skin or face. She didn't have any. There was no stippling on Caitlyn's wound. There was no stippling on her face, her neck, or anywhere on her. Dr. Weinberg found no evidence of soot deposits on her face, and he testified to you that based on his examination of her body, the muzzle of the gun had to be at least 3 feet or more, not closer, 3 feet or further back when it was fired. And if the shot came from 3 feet or more from Caitlyn's body, there is no possibility that Elowin is on Caitlyn's lap when the defendant fires. Elowin was in his arms. Even if the defendant had fired the gun in the way that he demonstrated or tried to demonstrate from the witness stand yesterday, he would have been closer to Caitlyn than 3 feet. The gun would have been closer still. Just as he told the police, the defendant grabbed Elowin and pulled her back. The defendant then had to step back to shoot Caitlyn Naffziger from the distance that her body shows the shooting happened from. Now, I want to talk to you a little bit about defense counsel's desperate efforts with respect to State's Exhibit 24A to talk about a hair on the slide. No one knows whose hair this is. No one. Defense counsel does not have to put on a case. They do not have to bring up evidence. But if this hair was the linchpin that solved it, they had every right and could have. And they chose to put on a case.
Objection, burden shifting.
That's not burden shifting. All she said was they could have said something if they wanted to. That was not burden shifting. You're an idiot, woman. That wasn't burden shifting. All she said was they could have presented it if they wanted to. She said that was not burden shifting.
Members of the jury, I'm going to strike the last sentence from the state's argument. Two other comments.
That wasn't burden shifting.
Had no burden to test any evidence in this case. And in fact, the defendant has no burden to produce any evidence in this matter. So with those instructions, I'll allow the state to continue.
Thank you, Your Honor. Ladies and gentlemen of the jury, defense counsel kept showing you this photograph, the word hair, because there was a hair in the slide. and they want you to somehow put together and believe that that is Caitlyn's hair, because that would somehow show you and prove by their theory that the defendant was closer than 3 feet. That you should use the fact that there's a hair on the gun, a gun that was next to the defendant, next to his child, in a pocket inside of a door in a car, and that you should somehow use this missing hair that hasn't been tested to decide that that means he was closer. That you should use this hair to disregard the testimony, the evidence, and the expert opinion of Dr. Weinberg. That doesn't do this. There's no inference as to whose hair. You know, I think we all understand, especially possibly the women on the jury, that hair falls out. It's everywhere. Hair on a gun isn't an inference that you can make. It doesn't matter whose hair it was. None of it would show that Dr. Weinberg's testimony is called into question. Dr. Weinberg, who testifies that this gun, the muzzle of it, the very tip, was at least 3 feet away from Caitlyn when it was fired. 3 feet from here to Caitlyn. You can make reasonable inferences from evidence. You cannot make jumps or wild conclusions. You have State's Exhibit 26B in evidence. That's the defendant's statement. This is an image from that, just showing you him in that room where he was interviewed, in that room with police officers on March the 1st of 2024. He didn't claim during this interview anywhere, at any time, that he acted to defend somebody, that he acted to protect Elwyn from being kidnapped. The defendant didn't shout it at the top of his lungs. He never once said he acted in defense of anyone. Unlike in his prepared testimony Friday of last week and yesterday, the defendant didn't tell the police that Caitlyn was kidnapping anyone or about to kidnap anyone. He also didn't tell the police about
It's not Jim
suspicions
McIntyre?
or make hypothetical statements that someone
It's
might be
Alien
outside of
Family
his
Bus?
apartment. He didn't tell the police that she was demanding that he pay her money in that moment. He talked a lot about times she'd asked for money in August of 2023, in September, October, leading up to this incident, but he never said those demands happened before he shot her. He didn't tell the police that she was demanding that he sell his car and give her money. He didn't tell the police that before he shot her in. These are all statements that he added over a year and a half later in support of his defense, to excuse. Specifically asked in that statement if Caitlyn was threatening anyone or causing any harm, he said no. He never once said he had to act to defend anyone. He never once mentioned a kidnapping. Not until yesterday in this courtroom did he make that statement. And even then, if you remember his testimony, he didn't say that he acted to shoot because his daughter was being kidnapped. He stated that he had shot and killed Caitlyn because in that moment, she was hurting Elwyn. You know, the defense has formed some kind of secret plan to take the children. Their plan involved code words and planned 911 calls. And it never happened because Caitlyn never called. You know, for a plan to be secret, the people involved in it don't tend to broadcast what they're about to do, don't tend to stand in front of the person they're about to steal a child from and say, I'm going to call the police, I'm going to take the kids. You know, about that plan, what defense has termed as a secret plan to go along with the broken promises because Caitlyn wasn't following the defendant's plans. The word plan comes up a lot, and I apologize because it's hard to keep them all straight sometimes. Caitlyn never called Brenda. She never texted her. She never asked for help. She never sent a code word, and Brenda never called 911. More important to your consideration, defense counsel advised you're not to Monday morning quarterback the defendant's choices, right? You're only to consider what he knew in that moment. And so if he didn't know that Brenda and Caitlyn had talked about this code word and 911 call plan, then he didn't consider it in the moments before he shot. What you do know is that the defendant didn't know about it and that it never actually happened. And because of those things, because he didn't know, you cannot use it to make the defendant's now stated belief that the defendant was going to kidnap the children become an actual belief or a reasonable belief. You know from his testimony that he only had suspicions. He didn't act on an actual belief, and his belief and his actions were not reasonable. On March the 1st of 2024, 16 hours after he had murdered Caitlyn, the defendant drove from Vermont.
I don't think you even need to go there with he believed the plan, but there was no evidence of the plan. I don't even think you need to go there because it wasn't a threat. There was no reason for him to shoot an unarmed woman that had a child on her lap. I don't even think you need to go there with he thought a plan that wasn't proven. I don't think you even need to go there.
Into Keene. He told you that he was on his way to turn himself into police, to turn himself in for shooting and killing Caitlyn. He drove past multiple police stations in multiple states. He drove past the New Hampshire State Police Barracks at Troop C. He wanted to be arrested on his own terms. He knew that he would be taken into custody. He knew there would be an investigation, and he was ready for that. That's why he came back. He knew that speaking to the police was his opportunity to provide a statement about what had happened, his statement, and he wanted that opportunity. He wanted to speak with police and tell them why he shouldn't be in trouble for what he had done. But he didn't turn himself in. He got taken into custody at gunpoint in front of those two little girls whose mom he had killed. He had 16 hours to think about and prepare for this moment. He had 16 hours to determine what to say, what exactly to say and how to say it. He'd given himself the time and the space to put any spin that he wanted on the events that occurred in his living room. He'd had time to consider what it was he was going to tell police, how he would portray himself, how he would portray Caitlyn.
Peaches.
Besides his 4-year-old daughter, there was no
You
one.
won't like them, they'll end up on the floor.
And so he waived his Miranda rights. He spoke with investigators for over 2 hours. They let him talk about anything he wanted to address and just asked him questions to tell them why he had killed Caitlyn. He said she refused to leave. He said she was bear hugging their daughter, that she wouldn't let go, that he tried to pull the child away. If you listen in the tape, there's about 40 minutes where he talks about their background and his disputes with her and their custody issues. It's not until almost an hour in that he actually starts talking about the moment that Caitlyn was in his apartment and leading up to his killing of her. In those moments, at around, I believe it's 1 hour and 4 minutes, the defendant says he was trying to grab Elowen and be like, hey, let go of Elowen, and she just wouldn't do it. And that was kind of the tick. And then he says, I think the moment was, Definitely very deliberate and fast. It was like the line had been crossed. That her not letting go, her continuing to hold Elowen, was the only thing, the tick, the moment in his mind when he decided to kill, the moment when he decided to walk for his gun. And you know that he decided to kill in that moment because he did grab his gun. He racked the slide. He switched the safety off, and he walked over to shoot Caitlyn. And you know that Caitlyn saw him as he picked up that gun, because he told you in his testimony, I mean, she was closer to it than he was. And you know because you heard that gun as it racked when Jill Terrio was showing it to you. You know Caitlyn heard the racking of that slide. And for what the defendant would admit to in his testimony yesterday, she at least tried to ask him what he was going to do with it. But he didn't answer, because within seconds, he had shot her in the head, and Caitlyn was dead on the sofa. The defendant shot and killed her without a second thought, and he never, not one time, said anything about Caitlyn being a threat or a danger to anyone in that moment, not until he took the stand yesterday. Compare that to his actions as he described them in that story, about a story that defense puts to you in their closing as explaining why he didn't call the police when Caitlyn was in his house. But it does so much more than that. It shows you the difference in behavior that the defendant has, the restraint that he can show, the fact that his muscle memory isn't all that's to him. A stranger trying to break into his home received more consideration than the mother of his children. That stranger was told to leave. He told them to go. He called the police. The defendant warned the stranger that he was armed with a gun. He went to the length to open the door and show the stranger the gun. He sat and waited with his loaded gun while the stranger tried the door, tried the windows, tried to break in. His muscle memory didn't take over. He didn't just shoot. The defendant never fired. He didn't shoot. The stranger walked away unharmed. But the mother of his children, she had to die. You listened to his statement during the presentation of the case. You have it in evidence, and you can listen to it again as many times as you want. You'll have a laptop back there that hopefully has a working CD player. You can listen to it, you can rewind it, you can jump to spots you want to hear. You should watch it. You should compare it to the statements that the defendant has now given to you from the witness stand. When you watch it, watch his demeanor, his body language, his facial expressions. Listen to the places where he hesitates or doesn't really answer the question that he's asked. Listen to the places where he scoffs, laughs, or smiles as he provides information to the police about where the bullet struck the mother of his children. Listen to the information he gave the police and his reactions and behavior when this was still fresh in his mind, 16 hours later, when he hadn't reviewed any evidence against him, but instead was telling things as they had happened. Even then, much like the defendant spent 3 hours sitting on this witness stand talking about child custody and his life before children, as well as his love of his children, the defendant spent the first 40 minutes of that interview talking about those same things. Again, the defendant begins discussing the shooting about 40 minutes in and the reasoning for it about an hour in. He says that she was holding Elowen and refusing to leave. That's it, nothing else. Nowhere in the statement does he say that he acted because Caitlyn was using force to commit any crime, let alone a kidnapping or being about to commit a kidnapping. Nowhere in that statement does he say she was harming anyone or physically threatening anyone. Many of the statements that he made yesterday are not in the statement to police. He never told the police that that night Caitlyn again demanded money from him or to sell his car. He never told the police that he was concerned that Caitlyn could reach for a gun. He never told the police that Caitlyn put her foot on the table and tried to use that to push away from him. He never told the police that Elowen shrieked or yelled or cried out because she was being hurt. He never told the police that he taught Caitlyn to fire that gun. You know, the defendant told you that during his testimony that he wanted you to believe that he's adding this information because he was misunderstood. He wasn't misunderstood. His words weren't misinterpreted. He just never said these things. Not for a year and a half. He is adding these things to change your opinion of him and of his actions, to try to get away with murder. The defendant spoke with detectives about every bad thing he believes that Caitlyn Naffziger had ever done to him or concerning their children. Is there any doubt in your minds that if she had said all these things he added from the witness stand, that he wouldn't have included them for the police? He'd had 16 hours to figure out to portray her as the villain and himself as the victim. The defendant has testified about being a Marine and being a father. Both of these things are true. But a third thing is true. He murdered Caitlyn Naffziger. He killed her out of anger that she was questioning his plans, anger that she was remaining in his house and wasn't leaving like his plan said she would. You got to hear those 3 hours of testimony in which the defendant spoke about his history and his love of his children. You'll never hear Caitlyn Naffziger's history, or about her love of being a mom, about her love for those same children she carried to term, her memories of their first years. You won't hear about Elowen's first Christmas when she was just 2 weeks old. All you got to hear was when Brenda Plamondon told you that Caitlyn was so loving and so happy to be a mom. You don't get to hear Caitlyn's story about those last moments of her life. She isn't here because the defendant killed her. The defendant killed her out of anger. He killed her because he wasn't going to lose power over her, he couldn't control her, and he wasn't going to swallow his pride again. The defendant is bigger and stronger and heavier than Caitlyn Naffziger. He talked with detectives about whether she'd ever been violent with him, and he told them he would never have registered it because she was so tiny. She couldn't hurt him if she tried. Not then, not ever. Not during any statements with the police and not from the witness stand. It's that Caitlyn never, ever hurt their children. There's no evidence that he even would try to say that. Now, the defendant wants you to believe that he shot this small, unarmed woman in defense of others, that this murder was justified, that he had no choice, that his use of force was somehow proportional, because the judge will explain to you that his use of force has to be proportionate to what he is responding to. The defendant wants you to believe that what he did was reasonable. He wants you to find that Caitlyn was committing or about to commit a kidnapping when he killed her, that she posed a danger when he killed her, and that this makes his killing valid, that he was right to shoot her in the head. All of this despite his clear testimony that he had shot and killed her just because she had hurt their child in the moment before the shot rang out. In order for you to find the defendant not guilty in this case, you would have to find that he acted in defense of others, that he both actually and reasonably believed that the mother of his children was committing a kidnapping or attempting to commit a kidnapping in that moment. Again, the defendant himself testified that he had suspicions, but you cannot kill someone over suspicions. It's not an actual belief, and it is not bull. The defendant testified that Caitlyn was threatening to call the police, that she threatened to take the children, but you cannot kill someone over a threat that is not reasonable and is not an actual belief. There is nothing in the defendant's statements to police or even his testimony that demonstrates that deadly force was necessary or proportionate to the reason that he said he fired. He was a Marine. He was trained in martial arts. She was unarmed. The defendant didn't use deadly force because he had no other choice. He shot an unarmed woman in the head. He murdered Caitlyn. You have an evidence, State's Exhibit 9A.
You're not done yet. I think you got your point across.
State's Exhibit 9A shows you Caitlyn as the defendant left her in that living room. This is a photograph of a mother sitting snuggled under blankets on a sofa, who has one foot kicked up on a coffee table, who has no shoes, no weapons, and poses no danger. This is a woman who moments earlier had a child on her lap, their child, their child. This is not a woman who was committing or about to commit a kidnapping when she was shot in the head. This is a woman with no friends in Berlin, New Hampshire, no friends in the area. Her family, a 2.5-hour drive away. She had never been there before. She had no car, no bus ticket, no means to leave. The defendant's reasons for shooting Caitlyn had nothing to do with the kidnapping. He told you he shot and killed her because he believed that Elowen was being hurt. He described that Elowen was hurt during his efforts to take her from Caitlyn. He said Caitlyn hurt her by holding her too forcefully. A person cannot use deadly force to protect someone from being held too tightly by their mother. That's not reasonable. The defendant did not have an actual or a reasonable belief that Caitlyn was kidnapping or about to kidnap these children. There's no justification, no excuse. This is not a reasonable use of deadly force. The facts tell you that. The law tells you that. Your common sense tells you that. The defendant shot this unarmed woman in the head while she was sitting on a couch, wrapped in a pink unicorn blanket. He shot her because she refused to leave and was holding their daughter. This wasn't an accident. It wasn't self-defense. It wasn't to prevent a kidnapping. It was murder, and he knows it. And now, so do you. The time for excuses is over. Please find him guilty of all of these charges.
Okay, members of the jury, we're at the point where I now going to provide my instructions to you. Once again, I do think under the circumstances of this case, I do think it is appropriate to take a brief break before I provide you with my instructions. So we'll be back at 11:35. You'll hear my instructions. After that, you will be ready to deliberate. And until then, again, until you have my instructions, I instruct you not to discuss the case with anyone amongst yourselves. And if anyone does so, please report that to a bailiff. As soon as we're back, I'll complete my instructions to you, and at that point, you can deliberate. Thank you. Please rise for your all rise.
Did he let him go to deliberate? Or does he still have to do jury instruction?
Okay, thank you. Please be seated. Members of the jury, at the beginning of the trial, I gave you some general instructions as to the law that applies to this case in order to give you some guidance as you considered the evidence in this case. We are now at the end of the case, so I will give you further instructions, and then you will retire to the jury deliberation room to decide your verdict. You will receive a written copy of these instructions when you are ready to deliberate. I'm going to repeat the instructions that I gave you at the outset because this trial has occurred over several days. Place no special emphasis on any of the instructions that I am repeating. I am repeating them only to remind you of my earlier instructions in the interest of being complete. In order to reach a fair and just verdict, you must, for example, you have to understand the definitions of the crimes with which the defendant is charged. You have to understand how convinced one way or the other you should be before you reach your verdict, and you have to understand what to consider in deciding whether to believe a particular witness. These instructions, as I said, will explain the law as to these and other matters so that you can reach a fair and just verdict. It is up to you to decide the facts of the case. You and you alone are the judges of the facts. You must decide the facts solely from the evidence in this trial. You apply the facts as you find them to be to the law as I give it to you in these instructions, and in this way you reach your verdict. You should decide the facts in this case without prejudice, without fear, and without sympathy. You are to decide the facts based only on the evidence, and the evidence in this case consists of the testimony under oath of the witnesses and any exhibits which have been admitted into evidence. Those exhibits will go with you into the jury deliberation room. There are certain other matters that you may not consider as evidence. The fact that the defendant has been arrested and charged with a crime is not evidence of his guilt. In this case, the defendant was charged by means of a document called an indictment. An indictment is simply a way of giving the defendant notice of the accusations against him. This type of document is a formal way of accusing him of a crime in order to bring him to trial. In your deliberations, you must not consider the fact of the defendant's arrest, the indictment, or the fact that the defendant has been brought to stand trial as evidence of the defendant's guilt. The possible punishment the defendant may receive if you return a guilty verdict should not influence your decision. The duty of imposing sentence is solely for the judge, and you should consider the evidence presented and base your verdict only on the evidence without considering the issue of punishment. What the lawyers have said to you is not evidence. In their opening statements and their closing arguments, the lawyers discussed their view of the facts to help you understand the evidence from their point of view. But the lawyers are not witnesses in this matter, and therefore they cannot testify. Therefore, what they said to you is not evidence in the case. If the lawyers stated the evidence differently from how you recall it, then you should follow your own memory of what the evidence was. Also, if the lawyers stated the law differently from the law as I explain it to you in these instructions, then you must disregard what the lawyers have said about the law and follow my instructions. During the trial, the lawyers made objections. Lawyers are supposed to object when they believe that certain evidence may not be admissible under our rules of evidence. Please do not hold it against either party if they made these objections, and sometimes these objections required bench conferences. If I sustained an objection and I excluded any evidence, you must not guess as to what the evidence might have been. If I ordered that a question and answer be stricken from the record, you must not consider either the question or the answer as evidence. Likewise, if I overruled an objection and I admitted certain evidence, then you must not give that evidence any special weight as a result of my ruling. I am not expressing views as to the importance of evidence when I make my rulings. I am merely applying the law, as is my duty. Throughout the trial, I must be fair and impartial, just as you are required to be. So if I said or did anything during the trial that causes you to believe that I favor one party over the other, I now instruct you that I do not favor either party in this case. The role of the judge is to run the trial in a fair and orderly manner, to decide the admissibility of evidence, and to instruct you, the jury, on the law that applies to the case. You, and you alone, as I said, are the judges of the facts, and you decide the verdict. Beyond explaining what you must not consider, I'm going to describe what you can consider as evidence. You should consider the testimony of witnesses and any exhibits that may have been introduced as evidence. In other words, you should consider only the legally admissible evidence and reasonable inferences that you can draw from the evidence. By reasonable inferences, I mean conclusions which reason and common sense lead you to draw from the facts that are proven to your satisfaction. There are two ways for a party to prove a particular fact in the case, either through direct evidence or circumstantial evidence. Direct evidence is direct proof of a fact, such as the testimony of a witness based upon personal knowledge. That is, what the witness actually saw, heard, or otherwise directly experienced. Circumstantial evidence is indirect evidence, which tends to prove a disputed fact by proof of other facts. In other words, circumstantial evidence is proof of a chain of facts and inferences that tend to prove whether the defendant is guilty or not guilty. Let me give you a brief example to demonstrate the difference between direct and circumstantial evidence. Assume that when you enter the courthouse, it is cloudy outside. While you are in court, you see someone come into the building who is wearing rain boots, the person is soaking wet, and they are closing an umbrella. If you could actually look out the window and see for yourself that there is rain falling from the sky, that would be direct evidence that it is raining outside. In contrast, if you cannot see for yourself whether it is raining outside, you could consider the facts and circumstances of the person you observed entering the court with the rain boots and umbrella to determine whether it is raining outside. That is an example of circumstantial evidence. You should consider both types of evidence, direct and circumstantial evidence. There is no legal distinction between the weight of direct evidence as compared to circumstantial evidence. You are permitted to give equal weight to both, but you must decide how much weight to give any evidence, whether it be direct
It's easy to
or
listen to,
circumstantial.
for sure.
There is, however, a rule relating to circumstantial evidence that you must keep in mind. If the state presents only circumstantial evidence to prove one or more elements of a charged offense, then in order to convict, you must find that the totality of the evidence as to those elements excludes all reasonable conclusions other than guilt. This means that if it is reasonable to arrive at two conclusions, one consistent with guilt and one consistent with innocence, I skipped a line. This means that if it is reasonable to arrive at two conclusions, one consistent with guilt and one consistent with innocence, then you must choose the reasonable conclusion consistent with innocence. In determining whether all reasonable conclusions other than guilt have been excluded, you should not consider any item of circumstantial evidence in isolation. Rather, you should consider each item of circumstantial evidence in the context of all the other evidence. You must understand, however, that this circumstantial evidence rule does not apply to direct evidence. If there is a conflict between two or more witnesses who offer direct evidence concerning certain facts, you must decide which witness to believe. For example, suppose there are two eyewitnesses to a crime, and one testifies that the defendant committed the crime, and the other testifies that the defendant did not commit the crime. This presents a situation where there is a conflict in the direct evidence. In this situation, you, the jury, must decide which witness to believe and whether, based upon all of the evidence, the state has proven the defendant's guilt beyond a reasonable doubt. Similarly, if only one witness provides direct evidence concerning an offense charged, then you must decide whether to believe that particular witness, considering the factors I have already outlined and any other considerations you would ordinarily use in deciding whether to believe a person based on your common sense and good judgment. Now, in reviewing the evidence, you should consider the quality of the evidence and not the quantity. It is not the number of witnesses or the quantity of the evidence that is important, but the quality of the evidence. That is, how persuasive the evidence is to you. In summary, you should consider all the evidence in the case and decide whether the state has proven the defendant guilty beyond a reasonable doubt. In deciding this case, you must decide the credibility of witnesses. That is, it is up to you to decide witnesses, then you must resolve the conflict. Simply because a witness has taken an oath to tell the truth does not mean that you have to accept the testimony as true. Use your common sense and judgment. Consider factors you use in deciding important issues in your everyday lives. For example, you may consider the following: the witness's appearance, attitude, and behavior on the stand and the way the witness testified, the witness's age, intelligence, and experience, the witness's opportunity and ability to see or hear the things about which the witness testified, the accuracy of the witness's memory, any motive of the witness not to tell the truth, any interest that a witness had in the outcome of the case, any bias of the witness or friendship or animosity the witness may have for or against any of the other people in the case, the consistency or inconsistency of the witness's testimony, whether or not what the witness said appears reasonable or unreasonable, whether what the witness said is consistent or inconsistent with the testimony of other witnesses, or with statements the witness made at another time. In deciding which witnesses to believe and how much of their testimony to believe, you should consider both the direct and cross-examination of the witnesses. If you believe that part of a witness's testimony is false, you may choose to distrust other parts also, but you are not required to do so. Inconsistencies and contradictions within a witness's testimony or between witnesses do not necessarily mean that you should disbelieve the witness. It is possible for honest people to witness the same event and see or hear things differently. You should evaluate inconsistencies and contradictions and determine whether they are important or unimportant. You need not believe any witness even though the testimony is uncontradicted, nor accept testimony as true simply because some or even all of the witnesses agree with each other. You may find the testimony of one witness or of a few witnesses more persuasive than the testimony of a larger number. The principles I've outlined regarding judging the credibility of witnesses apply to all witnesses, whether they are ordinary civilians, police officers, or otherwise. In short, you should consider the testimony of each witness and give it the weight you think it deserves. You can accept all of what a witness says, you can reject all of what a witness says, or you can accept some of it and reject some of it. It is up to you. Now, I've addressed what you should not consider and what you should consider in reaching a verdict. I'm now going to discuss how convinced one way or the other you must be, and this is referred to as the burden of proof. Under both our state and federal constitutions, all defendants in criminal cases are presumed to be innocent until proven guilty beyond a reasonable doubt. The burden of proving guilt rests entirely on the state. The defendant does not have to prove his innocence. The defendant enters this courtroom as an innocent man, and you must consider him to be an innocent man until the state convinces you beyond a reasonable doubt that he is guilty. If, after all the evidence and arguments, you have a reasonable doubt as to whether the defendant committed any one or more elements of the offense, then you must find him not guilty. Ladies and gentlemen, a reasonable doubt is just what the words would ordinarily imply. The use of the word reasonable means simply that the doubt must be reasonable rather than unreasonable. It must be a doubt based on reason. It is not a frivolous or fanciful doubt, nor is it one that can easily be explained away. Rather, it is such a doubt based on reason as remains after consideration of all the evidence that the state has offered against it. The test you must use is this. If you have a reasonable doubt as to whether the state has proven any one or more of the elements of the crime charged, you must find the defendant not guilty. However, if you find the state has proven all of the elements of the offense charged beyond a reasonable doubt, you should find the defendant guilty. Members of the jury, you must consider all of the instructions I give you, regardless of any opinion you may have as to what the law ought to be. The law, as I explain it to you, is the law you must follow in reaching your verdict in this case. Remember, all of the instructions I have given you throughout the case should be considered as a whole. So do not single out any particular instruction for special emphasis. As I told you at the outset, you will have a complete written copy of these instructions to have with you in the deliberation room. A crime is any breaking of a law for which the law provides punishment. All crimes have at least two parts. One, a criminal state of mind, and two, an act. In deciding whether a person is guilty of a crime, it is absolutely necessary for you to know both what the person's actions were and what his state of mind was. The phrase state of mind refers to what a person mentally believes his physical acts will accomplish. The word act refers to a physical deed. Thus, for a person to be guilty of a crime, he must have done the following two things. First, he must have had the required state of mind, and second, he must have physically acted to do something that is criminal. Unless a person both had the required mental state and acted to do something criminal, that person has not committed a crime. This means that if a person either did not have the required mental state, or if a person did not physically act to do something criminal, then he is not guilty of a crime. Remember that the reason crimes are given different names is that each refers to either a different mental state, or a different act, or a different mental state and a different act. Many persons do not realize that sometimes the only reason two identical acts are given different names refer to different mental states. For example, let us assume that two drivers of automobiles hit someone crossing a street. If one of the drivers intended to hit the pedestrian, whereas the other one did so out of carelessness, they would not be guilty of the same crime because they had different mental states. Thus, you can see how both the act and the mental state can make a difference. I am now going to discuss the definitions of the crimes with which the defendant has been charged. At the beginning of the trial, you heard the clerk read the charges against the defendant. You will receive copies of each of these charges with you in the deliberation room. In charge ID 223-7508C, the defendant is charged with the crime of second-degree murder. The definition of this offense has 3 parts or elements. The state must prove each element beyond a reasonable doubt. Thus, the state must prove that 1, the defendant caused the death of another, and 2, the defendant acted knowingly, and 3, the defendant did not act in defense of another. These are the elements of the crime of second-degree murder, knowing. Certain words in the definition need to be defined. A person acts knowingly when he is aware of the nature of his conduct or the circumstance under which he acted. The state does not have to prove that the defendant specifically desired or intended a particular result. What the state must prove is that the defendant was aware of the nature of his conduct or the circumstance under which he engaged in the conduct. Whether the defendant acted knowingly is a question of fact for you to decide. Keep in mind that there is often no direct evidence of a person's mental state because there is no way of examining the operation of a person's mind. You should consider all the facts and circumstances in evidence in deciding whether or not the state has proved that the defendant acted knowingly. Evidence has been presented that the defendant acted in defense of another with respect to this charge. When there is some evidence of defense of another, the state must prove beyond a reasonable doubt that the defendant did not act in defense of another. If you have a reasonable doubt on any of the charges as to whether the defendant acted in defense of another, you must find the defendant not guilty as to that charge. In deciding whether the defendant acted in defense of another, you should consider all the circumstances surrounding the incident. You should consider how the defendant acted under the circumstances as they were presented to him at the time, and not necessarily as they appear upon detached reflection. You should consider whether the defendant's belief that it was necessary to use deadly force was reasonable when he acted in the heat of passion. A person has the right to use deadly force on another person to defend a third person if, 1, he actually believed that the other person was committing or was about to commit the crime of kidnapping.
What just happened?
Believed that the other person was committing or was about to commit the crime of kidnapping. And 2, even if the defendant actually believed that the other person was committing or was about to commit the crime of kidnapping, the defendant's belief must be reasonable. In other words, there must be reasonable grounds for the defendant to have believed at the time that the other person was committing or was about to commit the crime of kidnapping. The distinction between deadly and non-deadly force depends on the defendant's mental state. If the defendant had the purpose to cause death or serious bodily injury, or if the defendant knew he was creating a substantial risk of causing death or serious bodily injury, then you should find that the defendant used deadly force. Serious bodily injury means harm to the body which causes severe, permanent, or protracted loss of or impairment to the health or function of any part of the body. If you find that the defendant purposely fired a firearm capable of causing serious bodily injury or death in the direction of another person, then you should find that the defendant used deadly force. Any other assault, confinement, or other action by the defendant is non-deadly force. Thus, if the defendant did not act with the purpose to cause death or serious bodily injury, and the defendant did not know he was creating a substantial risk of causing death or serious bodily injury, then you should find that the defendant used non-deadly force. The defendant must reasonably believe that the amount of force that he used was necessary for defense of another. A person is not permitted to use excessive force in defense of another, only a reasonable amount of force. The defendant can use the amount of force which he believed was necessary under the circumstances as long as, at the time, there were reasonable grounds for his belief. In Charge ID 221-7221C, the defendant is charged with a different variant of the crime of second-degree murder. The definition of this offense has 3 parts or elements. The state must prove each element beyond a reasonable doubt. Thus, the state must prove that 1, the defendant caused the death of another, and 2, the defendant acted recklessly under circumstances showing an extreme indifference to the value of human life. And 3, the defendant did not act in defense of another. These are the elements of the crime of second-degree murder, reckless. Certain words in the definition need to be defined. The term recklessly refers to the defendant's mental state. To prove second-degree murder reckless, the state must prove that the defendant acted recklessly under circumstances showing an extreme indifference to the value of human life. A person acts recklessly when he or she is aware of and consciously disregards a substantial and unjustifiable risk that his or her conduct would cause a certain result. The risk must be of such a nature and degree that, considering the circumstances known to him, its disregard constitutes a gross deviation from that conduct that a law-abiding person would observe in the situation. There are several components of a reckless mental state that the state must prove on this variant. They are: 1, the defendant was aware of a substantial and unjustifiable risk that his conduct would cause a particular result, and 2, the defendant consciously disregarded the risk. In other words, he elected to disregard the risk and take the chance that his conduct would cause a particular result. It is not enough for the state to prove that the defendant failed to become aware of the risk involved. The state must prove that the defendant was aware of the risk and consciously disregarded it. And 3, from what the defendant knew of his circumstances, his disregard of the risk was a gross deviation from what a law-abiding person would have done under the circumstances. The key words here are gross deviation. If you find that the defendant's actions were unreasonable or thoughtless, that is not enough. To find the defendant acted recklessly, you must find that his disregard of the risk was a substantial departure from what a law-abiding person would have done under the same circumstances. For a killing to be second-degree murder, the defendant must not simply act recklessly, but rather must act with human life. This means something more than being merely aware of and consciously disregarding a substantial and unjustifiable risk of death. The risk involved and the disregard must be so blatant as to manifest extreme indifference to the value of human life. With regard to element 3, relative to defense of another, you should apply the law I gave you in connection with the second-degree murder knowing definition above. In charge ID 221-7222C, the defendant is charged with the crime of reckless conduct with a deadly weapon. The definition of the crime of reckless conduct has 5 parts. The state must prove each part of the definitions beyond a reasonable doubt. Thus, the state must prove that 1, the defendant engaged in conduct that either placed or may have placed another person in danger of serious bodily injury, and 2, the defendant acted recklessly, 3, the defendant used a deadly weapon, and 4, the deadly weapon was a firearm, and 5, the defendant did not act in defense of another. Certain of these terms must be defined. Serious bodily injury means any harm to the body which causes severe, permanent, or protracted loss of or impairment to the health or of the function of any part of the body. The term recklessly has the same meaning as that set forth above. Deadly weapon means any firearm, knife, or other substance or thing which, in the manner it is used, intended to be used, or threatened to be used, is known to be capable of producing death or serious bodily injury. A firearm is not necessarily a deadly weapon. Whether the specific manner in which the defendant used the firearm and the circumstances surrounding that use rendered the firearm a deadly weapon is a factual issue for you to decide. With regard to element 5, relative to defense of another, you should apply the law I gave you in connection with the second-degree murder knowing definition as above. In charge ID 221-7223C, the defendant is charged with the crime of endangering the welfare of a child. The definition of this crime has 5 parts. The state must prove each part of the definition beyond a reasonable doubt. Thus, the state must prove 1, the defendant owed a duty of care, protection, or support to a child under 18 years of age, and 2, the defendant purposely violated that duty, And 3, in doing so, the defendant's action endangered the welfare of the child. And 4, the defendant acted knowingly with respect to the endangerment. And 5, the defendant did not act in defense of another. Certain of these terms must be defined or explained. The term purposely means that the state must prove that the defendant had the conscious object to do certain acts or to achieve a certain result with respect to the duty that he owed to the child. The key words here are conscious object. Conscious object means that the defendant had a specific intent. It means that the defendant desired to cause a certain result or to do the prohibited acts. It is not enough for the state to prove that the defendant knew or was aware of what he was doing, nor is it enough for the state to prove that the defendant created a risk of injury or harm. To prove that the defendant acted purposely requires more than that. It requires proof that the defendant specifically intended or desired to bring about a particular result or to do the particular acts. Whether the defendant acted purposely is a question of fact for you to decide. Keep in mind that there is often no direct evidence of a person's mental state because there is no way of examining the operation of a person's mind. You should consider all the facts and circumstances in evidence in deciding whether or not the state has proven that the defendant acted purposely. Your determination as to whether the defendant acted purposely is with respect to the action he took relative to his duty of care, protection, or support, and not with respect to the effect of such action. The term welfare means general well-being in any respect. Endangerment means the act or an instance of putting someone or something in danger or exposure to peril or harm. To find endangerment, the state must prove that the defendant engaged in behavior creating an actual set forth above. Your determination as to whether the defendant acted knowingly is with respect to the effect of the actions he took toward the welfare of a child. With regard to element 5, relative to defense of another, you should apply the law I gave you in connection with the second-degree murder knowing definition above. Each of the charges against this defendant constitutes a separate offense. You must consider each charge separately and determine whether the state has proven the defendant's guilt beyond a reasonable doubt. The fact that you may find the defendant guilty or not guilty on any one of the charges should not influence your verdict with respect to the other charges. In this case, the defendant is charged with 2 separate counts of second-degree murder. One indictment charges the defendant with second-degree murder under a theory of a knowing mental state, and the other indictment charges the defendant with second-degree murder under a theory of a reckless mental state. These indictments are presented on alternative theories of culpability. You will deliberate and reach a verdict on each indictment. You should evaluate all of the evidence and apply that evidence to each indictment. The fact that you may find the defendant guilty or not guilty on one indictment should not influence your verdict on the other indictment. The principles I've outlined regarding judging the credibility of witnesses apply to all witnesses, whether they are ordinary civilians, expert witnesses, medical personnel, police officers, or otherwise. In short, you should consider the testimony of each witness and give it the weight you think it deserves. You can accept all of what a witness says, you can reject all of what a witness says, or you can accept some of it and reject some of it. It is up to you. Beyond witness testimony, you will also be provided with certain exhibits that were introduced by the parties and allowed by the court into evidence. The court notes that some of the exhibits are considered tangible or physical exhibits, specifically including a firearm that was introduced into evidence. A lock has been affixed to the firearm to ensure your safety. If you would like to examine either the firearm or the ammunition, please notify the bailiff and those exhibits will be brought to you. However, you will not be allowed to examine the firearm and the ammunition at the same time. Further, although you are allowed and encouraged to view and inspect these items, please take no action with respect to these exhibits or any of the other exhibits for that matter, which would in any way impair their ongoing use by the court as items of evidence. Members of the jury, the principles of law that I've given to you are intended to guide you in reaching a fair result in this case, which is important to both of the parties in the courtroom and to the court. You are to exercise your judgment and your common sense, as I said before, without passion, without prejudice, and without sympathy, but with honesty, understanding, and due deliberation. When you have considered and weighed all of the evidence, you must make findings with respect to the charges that are before you. You must decide if the state has proven each of the elements of each of the charges beyond a reasonable doubt. In other words, if you have a reasonable doubt as to whether the state has proven any one or more of the elements of each of the offenses charged, you must find the defendant not guilty as to that charge. However, if you find that the state has proven all of the elements of any of the offenses charged beyond a reasonable doubt, then you should find the defendant guilty as to those charges. Let me remind you that a reasonable doubt is just what the words would ordinarily imply. The use of the word reasonable means simply that the doubt must be reasonable rather than unreasonable. It must be a doubt based on reason. It is not a frivolous or fanciful doubt, nor is it one that can easily be explained away. Rather, it is such a doubt based upon reason as remains after consideration of all of the evidence that the state has offered against it. Your verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each and every juror agree with the verdict. In other words, your verdict must be unanimous. All 12 jurors must agree that the state has proven each element of each of the charges beyond a reasonable doubt as to that charge. You may find the defendant guilty on one, more than one, all, or none of the charges. When you have arrived at your verdict, let the bailiff know, and you will be returned to the courtroom where the foreperson will render that verdict orally in response to questions that the clerk of court will ask you. The foreperson should see to it that the jury takes up the issues that are before you. He or she should see to it that each juror has a full, fair, and adequate opportunity to present his or her views, positions, and arguments with respect to the law and the evidence. As your first order of business, you shall decide upon your foreperson, write the foreperson's name on a piece of paper, and notify the bailiff of your choice by handing the paper to the bailiff. Ladies and gentlemen, this case is important to both of the parties, the state and the defendant. In your deliberations, you should follow these instructions which the court has given you. You should make a conscientious effort to determine what a fair and just result is in this case, because that is your highest duty as officers of this court. It is your duty as jurors to consult with one another and to deliberate with a view towards reaching an agreement, if you can do so without violence to your individual judgment. Each of you must decide the case for yourself, but do so only after impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your views and change your opinion if you are convinced it is erroneous, but do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or merely for the purposes of returning a verdict. If any question of law should arise during your deliberations, the foreperson should write that question out, sign it, hand it to the bailiff, and the question will be brought to me, and I will return it to you with an answer. If, however, your question is one of fact, then I will not be able to help you because, as I told you before, you and you alone are the sole judges of the facts, and therefore you must rely upon your collective memory to resolve a factual dispute. A verdict form has been prepared for convenience, which contains spaces where you check off whether you find the defendant guilty or not guilty on each of the charges. Once you have finished your deliberations, the foreperson will complete the verdict form, sign it where indicated, and then notify the court officer who will give the form to me. After I review it, I will return it to the foreperson, and you will return to the courtroom where, in response to inquiry by the clerk, the foreperson will announce your verdict here in open court. Thank you for your attention. I will now select 4 alternates. Members of the jury, under state law, we provide for alternates beyond the 12 required to deliberate in the event that something occurs during the course of the trial. And I will give further instructions about the alternates once I pick them, but that is the process we are about to undertake. Counsel, I have prepared the appropriate number of cubes, and I'm going to shake the cube, shake the jar. I'm going to not look at it, and I will select one. Then I will repeat that process. Any objection to that process, counsel?
No, Your Honor.
Okay. Juror number 1. Juror number 4. Juror number 2. And juror number 5. The alternate jurors are still members of the panel, even though they will not be deliberating at this time. Because it may be necessary for the alternates to rejoin the deliberations, I instruct the alternates that while you remain segregated from the deliberating jurors, you are not to discuss the case with anyone, including amongst yourselves. When the jury reaches a verdict, you will be returned to the courtroom to hear the verdict. I want to thank the alternates for your service, and in a moment when we recess, I would like to see the alternates briefly at the bench. The jury may now retire to the jury deliberation room. It will take a few minutes, but I will see to it that the evidence and a copy of these instructions are brought to you. Anything further, counsel?
Could we approach your honor briefly?
Oh, they got to approach one last time.
The jury may retire to the deliberation room, and I will see the alternates at the bench, please. Thank you.
Okay. So we're on jury watch. What do you want to do? Do you want to... That new trial started yesterday, so we can do that while we're on verdict watch. We can get caught up, or we can go back and finish up Brooks. It's up to you guys. The new trial is in Waukesha County, so we're going to be in the good state-of-the-art courthouse that has a good sound system, so we should be able to hear. It's some guy killed his girlfriend and hid her body. It's called the Hidden Body Murder Trial. And we can do that. We have to catch up yesterday because it started yesterday. Are you serious, Wiggles? Why would you want to do that? The new Wisconsin one? Okay. I need to take a break. I have a couple phone calls I need to make, and I will get it set up. So, give me about 15, 20 minutes, I guess, and I will be back with a new trial, okay? So I will see you guys in like 20 minutes. Okay. See you in a bit.